I warmly welcome you to this session on patent commercialization and IP management strategies. A patent is not merely a legal document that provides exclusive rights to an invention. It is also a valuable business and strategic asset. The real value of an innovation can be realized when intellectual property is effectively managed, protected, commercialized, and transformed into economic and social benefits. Patent commercialization refers to the process of converting patented invention into marketable product, service, process, or business opportunity. At the same time, IP management provides a systematic framework for identifying, protecting, maintaining, exploiting, and monitoring IP assets. An effective IP management strategy helps the organization to maximize the value of patents, trademarks, copyrights, trade secrets, and other forms of intellectual property. So, with this above few information, I once again welcome all the participants for the Day 5 Faculty Development Program on Patent Commercialization and Intellectual Property Management Strategies. Today, we move beyond patent protection and focus on a very important question: how can intellectual property be converted into meaningful economic and societal value? Our theme for today program is from protection to profit, strategic pathway for IP success. Over the previous 4 days, we have progressively developed our understanding of intellectual property in the proposed 5 days faculty development program. We began with the foundation of intellectual property, including patents, copyrights, and trademarks. We then moved into patent drafting and filing, followed by prior art search, novelty, and examination strategies. Day 4 focused on institutional IPR policies and researcher rights. Today, on day 5, we bring all these concepts together and focus on commercialization and strategies for IP management. The ultimate objective is not simply to obtain a patent, but to ensure that protected knowledge creates a real world value. Today's session is structured around 5 important pillars. The first one is IP strategy development, where innovation is aligned with organizational and business objectives. Second is IP portfolio management, which focuses on building and maintaining valuable intellectual assets. The third one is licensing and technology transfer, through which intellectual property can reach industry and generate revenue. Fourth is commercialization strategies, which deal with the transforming innovations into market ready solutions. And the fifth is risk and dispute management, which helps organizations to protect their intellectual property and minimize the potential risk. Along with these pillars, we will consider the practical insights, case discussions, assessment, and overall FDP wrap up. Let us now look at the core framework. The journey begins with an idea and innovation that has a potential value. The next step is to protect that innovation through appropriate intellectual property rights. Protection alone, however, is not sufficient enough. We must manage the IP portfolio very effectively. The next stage is technology transfer, where licensing or other mechanisms can move the technology towards the market. Finally, we arrive at profit or value creation, where commercialization converts intellectual property into measurable economic and social benefits. The key message is very clear: a patent that is never licensed transferred, or commercialized may remain only a cost rather than becoming a valuable asset. Now we are going to see the first pillar, IP strategy development. A patent without a strategy is simply a legal document. A well developed strategy converts intellectual property into a meaningful business decision. Organization must align their research and development outputs with their institutional or business objectives. They must decide which innovations should be patented, which may be published, and which may be protected as trade secrets. Geographical filing and the time of patent applications should also be connected with market entry plans. A systematic filing roadmap linked with funding and product development milestones can help to prevent unnecessary expenditure and create a stronger competitive position. Ultimately, a good IP strategy creates credibility among investors, licensees, and strategic partners. The second pillar is IP portfolio management. A strong portfolio is not necessarily the portfolio with the largest number of patents. What matters is the quality, relevance, and commercial potential of the intellectual assets. Organizations should classify their IP according to technology areas, markets, and business units. Each patent can be evaluated based on factors such as novelty, strength, scope, and remaining life. It is also important to identify the technological gaps and opportunities by studying competitor filings. Renewal deadlines and maintenance obligations must be carefully monitored. Low value assets may need to be pruned, while related patents can be organized into stronger patent families. Regular portfolio audits help organizations to understand where their intellectual property is creating value and where improvements are required. The third pillar is about licensing and technology transfer. Licensing provides an important route for converting intellectual property into revenue without requiring the inventor or institution to manufacture and sell the product directly. Different models can be considered, including exclusive licensing, non exclusive licensing, and field of use licensing. Other possibilities include cross licensing, spin offs, startups, and university industry technology transfer agreements. A successful licensing agreement should clearly define the financial terms such as upfront payments and running royalties. It should also specify territory exclusivity. So it should also specify the territory, performance milestone, and confidentiality requirements. Strong prior art evidence and sound technical documentation can significantly strengthen the negotiating position of the IP owner. The fourth pillar is commercialization strategy. There is no single commercialization pathway suitable for every innovation. An institution may commercialize the technology directly, license it to an established industry partner, create a startup, or enter into a joint venture or strategic alliance. The right choice depends on the market readiness, capital requirements, manufacturing capabilities, and technology readiness level. Incubators, IPR cells, and technology business incubators can play an important role in bridging the gap between laboratory research and the marketplace. Most important thing, commercialization planning should be aligned with the remaining patent term and the expected market entry timeline. The fifth pillar is about risk and dispute management. The intellectual property risk can significantly affect the value of research and innovation. Before launching a product, the organization should consider freedom to operate, such as regular IP audits can identify the gaps at an earlier stage. Organizations should also monitor the competitor patent filings and market activities. Clear records relating to inventorship, assignment, and ownership are extremely important. When disputes arise, organizations need to understand the options such as opposition, revocation, invalidation proceedings, litigation, settlement, mediation, and arbitration. The best approach is to develop a response protocol before a dispute occurs. Let us now go deeper into IP valuation and commercialization models. There are several approaches to valuing intellectual property. The cost approach considers the investment made in research, development, filing, and other related activities. The market approach compares the IP with the similar licensing or IP transactions. The income approach estimates the future cash flows that the intellectual property may generate. Another important method is relief from royalty approach, which estimates the royalty that would otherwise have to be paid to use comparable intellectual property. Commercialization itself can take several forms, including licensing out, startups, assignment or sale, and joint ventures. Each option has a different balance of control, investment, risk, and potential return. Let us now learn from few practical examples. In university technology transfer, a dedicated IPR cells can help institution to license inventions to industry and generate royalty income as well as opportunities for sponsored research. In the case of startup, faculty and student inventors can build new ventures around a core patent. In infringement situations, strong ownership records and prior art documentation can support negotiations and licensing settlements. Across this example, one common lesson emerges: IP creates value only when ownership is clear, documentation is strong, and commercialization is deliberately planned. Let us now consider how these concepts apply to different stakeholders. For faculty members and research scholars, IP decisions should become a part of research planning process with invention disclosures documented at the appropriate stage. For innovation and IPR cell members, systematic portfolio audits and a structured licensing outreach can strengthen institutional IP management. For industry professionals, freedom to operate searches and licensing can provide access to external innovations without depending entirely on internal research and development. For students and startup founders, intellectual property can become one of their most important early stage assets. The message is simple: protect your core innovation before presenting it to the market. As we approach the conclusion of today's session, let us recall the six major key takeaways. First, we came to understood the difference between IP valuation and commercialization models. Second, recognize the importance of licensing, franchising, and technology transfer. Third, develop strong and carefully curated IP portfolios. Fourth, use IP audits and risk management practices effectively. Fifth, adapt commercialization strategies suited to startup and innovators, and finally learn continuously from real case studies and industry best practices. These principles can help to transform intellectual property from a protected right into a sustainable source of innovation and value. Dear participants, we have now reached the conclusion of day 5 and the final day of our faculty development program. Over these 5 days, we have traveled from the fundamentals of intellectual property to patent filing, drafting, examination, institutional IPR practices, and finally, commercialization and strategic IP management. I hope this FDP has provided you with practical knowledge that you can apply in your research, teaching, institutional activities, industry practice, and entrepreneurial initiatives. Always remember one thing: protection is the beginning, commercialization is the pathway to add value. Thank you for your active participation and valuable engagement through this program. I sincerely appreciate your time, interest, and commitment. Thank you, and I wish you continued success in protecting ideas, building innovations, and creating meaningful impact.